take our, I'm just going to need a little bit of cooperation so I can see. I love you all, but we'll see. I do want to welcome Special Agent Coleen M. Rowley of the FBI. She's been an FBI agent for 21 years. She's currently the Chief Division Counsel for the Minneapolis Field Office of the FBI. She came to the attention of this committee when she wrote a letter to Director Mueller that was given to members of Congress. And her letter refers to a number of issues this committee has heard from other FBI agents in the past. Senator Hatch and I felt that by the nature of the hearing we're having today, it would be good if she testified. And did you want to say something before it starts?
Fine. I'm just looking forward to your testimony.
Mr. Chairman, could I say something?
The Senator Moussaoui, of course.
Yeah. Well, I thank you, Mr. Chairman, because Special Agent Rowley is a native of my home state of Iowa, and she's also a native of my wife's hometown of New Hampton, Iowa. But more importantly, Agent Rowley is a patriotic American who had the courage to put truth first and raise critical but important questions about how the FBI handled a terrorist case before the attacks and about the FBI's cultural problems. Agent Rowley, your testimony today is a great service to this committee, the entire Congress, the FBI, and the American people, and I thank you for coming. We should be honored to hear your testimony today. People like you who come forth to, as I put it, to commit the truth, a very terrible sin among some federal employees, but you come forth with important information about the FBI. There's been heroes like Fred Whitehurst before you who exposed the FBI crime lab scandal. And we had 4 agents last summer who revealed disparities in discipline and a pattern of retaliation against those who investigated misconduct inside the FBI. Agent Rowley has thrown the spotlight on specific and general problems happening at the FBI before the terrorist attacks, and she has important insights with her perspective from the field about what the FBI can do to change. The FBI must improve so it can prevent future terrorist attacks, and her testimony, I believe, is very important to help this happen. Ms. Rowley, I believe, is a dedicated public servant who tells it like it is. She wanted to be an FBI agent since she was 5 years old, and she had has had a distinguished 20-year career at the FBI. She worked in a variety of offices, including New York, where she investigated mafia after learning Italian, and worked with people like Rudy Giuliani, Louis Freeh, and Michael Chertoff. She worked in the Minneapolis division now since 1990 in a number of areas, including as the ethics officer. Agent Rowley, I thank you again for agreeing to testify today so that we can hear your constructive criticism of the FBI to help it reform and to help it improve. Thank you. Thank you, Mr. Senator.
Well, Ms. Rowley, both Senator Wellstone is the senior senator from your state, and Senator Grassley, who is from your state of birth, have said very good things about you, and they both have gone out of their way to talk to members of the committee. With all that, now we'd like to hear from you. And I should mention a roll call vote has started. Why don't you begin your statement? If we have to stop at some point, I will. It won't be because of something you said. It's only because we have to vote in person. Go ahead.
Well, the first thing I want to do is thank you for the opportunity to appear today. I never really anticipated this kind of impact when I wrote this letter to Director Mueller over 2 weeks ago. I don't know if you know, I think they've been saying I anguished over this a week. It wasn't even quite a week that it was more like a 3-day period, and it was a fairly sleepless 3-day period when I began to initially just jot down my thoughts, because I knew I had to appear before the staffers of the Joint Intelligence Committee, and I didn't want to forget anything. And also, you'll probably find out I'm a little better on paper than I am verbally, so I was kind of afraid of that. That was one of the reasons I started to write it down. I also had another big impetus that was kind of behind this all, and one of the things was I saw the new direction of the FBI. Perhaps it was kind of hard to discern when it was first announced, but I thought I saw some impetus towards a little more additional bureaucracy and micromanaging from headquarters. And I wanted to point out to Director Mueller that that seemed to fly in the face of what we should have learned from September 11th. And the two things were the impetus for the letter. Of course, you know, I have many years of experience in the FBI. I really do care really about the FBI. I've invested, you know, almost half my life in it. And I do care also about our protection now. I've got 4 children. A lot of my friends have children, and I really think we ought to be doing our best to try to prevent any future acts of terrorism. I did, in the last couple of weeks, receive hundreds. I was counting them for a while, but I lost track. But I received hundreds of emails and telephone calls from agents, mostly agents, some supervisors, some prosecutors, some retired FBI leaders. And I'm not going to presume to speak for all of those people, but when I looked at them, and I've read most of them, there's a few I probably haven't gotten a chance to look at that have come in since I left, but of the ones I looked at, I did see a real common theme emerging. It seems like it kind of struck a chord with a lot of people about this idea about the bureaucracy. A lot of other agents told me similar stories about cases that had, you know, maybe unjustifiably not gotten anywhere. And I have a whole stack of those. I think there is really the main thing being a real strong consensus that we need to streamline the FBI's bureaucracy in order to more effectively combat terrorism. We need that agility that Director Mueller was speaking of this morning, that agility and ability to quickly react. And I really see that as if you get too top-heavy with too many layers, he also mentioned that problem, that you are going to be stymied. I was encouraged by Director Mueller's testimony this morning because I think many of his ideas do seem to go in the right direction and actually are quite consistent with the various items I had in my letter to him. He really has an extremely difficult job, and that's an understatement. When I talk about trying to trim the bureaucracy a little bit, I don't know how you can underestimate that. It's been tried before and failed, and he just has a tremendously difficult job, which I can appreciate. I want everyone to know that no one today previewed in the FBI. Of course, they gave me approval to be here, but no one read the statement I did. I did this one quite quickly because I didn't know I was coming until recently. And in this statement, which I'm not going to read because you can read it when you want to, I have some ideas in here. Some of these ideas, again, come from other agents, some of whom are more experienced in intelligence than I am. And then some of them are my own ideas. I am the legal counsel, so some of the legal issues are things that I've seen as an issue that have arisen in the past few years. And you can read that at your leisure, and if someone wants to ask me a specific question about any of those, that's fine. Part of, I guess, what I can maybe go on beyond what Director Mueller, I guess what I'm going to try to do is the FBI made mistakes prior to September 11th. I made a little mistake. If you look at my letter, I made a mistake on the first page. I got the date wrong. It was August 16th. I mean, I proofread it once and I missed it. We all make mistakes, and I think that there are other levels of our criminal justice system. There are other federal agencies I'm not going to talk about, but there are also the prosecutors when you try to go criminal. There's entities in the Department of Justice, and so to some extent I've kind of broadened some of what I have written in my statement to include those other criminal justice entities that, you know, the FBI is real important, but there's certainly other entities that are very important here too. I was also encouraged. I don't know if anyone asked a question about it today, but when I read Director Mueller's statement, he points to integrity. I think it's the last page also, and he does point to that as an issue. And I'm very encouraged by that because, of course, if you look at the end of my statement, I think integrity is extremely important. Some of the people this morning did ask questions about how are we going to effectively combat terrorism. We're going to be in a proactive environment, which definitely has the potential of maybe interfering with people's civil liberties. And how are we going to still protect those civil liberties? And I honestly think integrity really plays into this whole item. A lot of when you're asking for some new law or some new authority, it's perhaps not only what the law allows you to do, but it's how it's going to be done. And then it really boils down to an issue of trust with the agency or the entity that you're giving this particular power to. And there are potentials for abuse if you go over that line. And I think as an agency, we have to be so completely truthful and honest that people are able to trust the FBI, that we will not cross those lines and commit any kind of civil rights violation or collect too much information, etc. That basically is all I want to say, and then if anyone has a question from my statement.
Ms. Rowley, we will. And what I'm going to do now, we have about 4 minutes left in this vote. I'm going to suggest everybody go and vote. We'll stand recess for a minute, or the amount of time it takes, come back, and that way we'll be uninterrupted. Thank you.
Based on Director's testimony.
If everybody could get must be hot weather. Nobody wants to go outside. Agent Rowley, you may be interested in knowing, and I haven't even had a chance to share this with Senator Grassley. A copy of this has gone to Senator Hatch. Dan Bryant of the Department of Justice has sent me a letter following a request I made, assuring both me and Senator Hatch there will not be any retaliation against you in any form for the letter you sent to the FBI director. Of course, that would also extend to the testimony here. I will put this letter to Senator Hatch and myself in the record, and Senator Grassley and I have both notified the Attorney General and the Director that we would be following this matter carefully anyway. Let me ask this question of you, and I asked this question basically to Director Mueller this morning, so I want to ask you as well. To your knowledge, did the agents in Minneapolis, or at headquarters for that matter, ever try to do a routine search for reports on aviation schools or pilot training on the automated case system? I'm not talking about putting in somebody's name, but for search words like aviation schools or pilot training. Anybody do that?
Well, I know a little bit about our ACS system and the records we have, and as well as the search methods we have, because I also do our Freedom of Information requests. And of course, there are strict rules in place about how we search and when people write to us, you know, if we find their name. Our main system of records, our central record system, is indexed according to the name of the subject usually. So for instance, in a case where a particular suspect was named, the normal method of searching would be to search that name only. We do have the ability to search some text for a word. But unlike, for instance, if you were doing LexisNexis research, you can put in the and there's all different ways that you can search. Our FBI search is probably the most fundamental, rudimentary thing. You can just put in a word. So, for instance, if you put in airline to do a text retrieval, you would get up such a volume of records that it would be impossible to review. It's almost impossible to do just a one-word text. Now,
You couldn't put in aviation schools?
well, what you can't do, for instance, in LexisNexis, when you're searching for things, you can put those qualifiers in that narrow it down.
Right.
And we have no way of doing that. We can put a word in.
You could put in aviation,
I think we could.
but you couldn't put in aviation schools.
No.
So you might
You would be getting aviation, and you would just be getting records that you couldn't possibly review. Now, what the normal method is we do search those names. And that's because the subject's names are indexed. So for freedom of information, that's what I do. And you do, I think he mentioned that you have to have the correct spelling. That's right. I mean, if you're one letter off, you may not turn up a record.
But this doesn't do you much good if you're looking for somebody, for example, used nitroglycerin in types of bombings and is going around with an alias, which changes bombing to bombing. What about the director said in his testimony that your office couldn't have brought up the Phoenix electronic communication on the computers and use it in connection with the Moussaoui case, but that headquarters could have done that. Is that your understanding?
I don't know specifically about that, EC, but I do know that prior to September 11th, a number of classified documents, and probably almost all classified documents, were blocked, so that only certain people on a need-to-know basis would be able to. If you went into the computer, for instance, and you didn't have that access, you're not going to be able to see those things. It was also in public corruption cases, other types of cases that we had this blocking. And it served a good purpose in a way because, you know, it really keeps the people maybe from abusing it.
But if you have, I mean, suppose you have a cleared person, the head of your office, head of the Phoenix office, and others, they want to do a computer search on the FBI ACS computer network. It's still difficult for them to do. Is that correct? Is that clear?
That's true. I don't know exactly how this blocking, you know, what people in each office were unblocked and which weren't. Typically, it was the people who had a need to work on that case only.
Unfortunately, some of the people may know something about it are not going to be able to go much further. You wrote that a supervisor at FBI headquarters made changes to the Minneapolis agent's affidavit. I'm talking about the FISA process now. You wrote that they made changes to the agent's affidavit that, quote, to use your words, set it up for failure. Now, the New York Times has also reported that another headquarters agent was basically banned from the courts, from the FISA courts, by the judge based on his past affidavits. I know that in response to some of these problems, the FBI has instituted the so-called Woods procedures, and we put that in the record. It's been declassified, put in the record this morning. Do you think that some of these problems with the FISA court made headquarters more cautious and risk-averse in processing the FISA applications to the court?
I've never actually served at headquarters, so I guess I would only be speaking from hearsay, and as well as maybe the opinions of some of the people that have called me and emailed me. I think that when incidents occur where people in the FBI are disciplined or even investigated possibly, I think there are some consequences to that, and it does in the future make them much more careful. In the instances that I'm aware of in our office where that's happened, we have typically, in order not to repeat the problem, we've instituted some kind of procedure that makes it more difficult. So I think that, in a way, you know, from what I know of it, and again, I've never served in headquarters, that I would probably agree.
You also wrote that you and the agents in Minneapolis were frustrated with the headquarters agent that was assigned to the Moussaoui case, and it actually hindered your investigation. Did you or any other supervisor or agent in Minneapolis call the agent you were concerned with, call his supervisor or others in Washington to complain about this before September 11th?
I'm, of course, a little bit restricted in what I can talk today about the events of pre-September 11th. I had put that in my statement. I failed to mention it earlier. When I comment, I'm going to try to comment in a general way and just avoid the specifics prior to the events prior and not get into true, real facts. When I wrote the letter to Director Mueller, I think some of the news accounts may be misunderstood. I really was speaking more from a third-party perspective and talking about what I saw our agents and other people in our office, as opposed to me personally. There was a word in the first page. I said I had a peripheral role, and I think that's very accurate. I did have a role, but it was peripheral. And when you ask if other people took these actions, you know, I will say this. We have a culture in the FBI that there's a certain pecking order, and it's pretty strong, and it's very rare that someone picks up the phone and calls a rank or two above themselves. It would have to be only on the strongest reasons. Typically, you have to pick up and call pick up the phone and talk to somebody who is at your rank. So when you have an item that requires review by a higher level, it's incumbent for you to go to a higher level person in your office and then for that person to make a call.
Has the Inspector General talked to you about this case?
I've had a call from the Inspector General, but so far we haven't gotten into any real facts or anything.
And when did he first contact you?
I was contacted by an investigative counsel from the Office of Inspector General, and that's all. And it was basically just to introduce herself.
And how long ago?
It was last week, I think, just a day or two after Director Mueller announced that it would be turned over to the Office of Inspector General.
Thank you. And you raised an important issue also about the so-called McDade law in your testimony. You know, that law was slipped into a massive omnibus appropriations bill, or some of us call it ominous appropriations bills, back in 1999. Senator Hatch and I and Senator Wyden have been trying to fix this problem. In fact, we introduced, what was it, S-1437 to fix the problem. I want you to know there's some of us on the committee that recognize it is a problem, and Senator Hatch and I are trying very much to fix the problem. We'll keep trying. Eventually, I hope we're going to be successful. We came very close. We thought we had it fixed in the USA Patriot Act, but others didn't want it to go forward. Been able to, but I'm committed, and I think I can speak for Senator Hatch. He's committed to get it fixed. Senator Hatch.
Well, thank you, Mr. Chairman. I want to welcome you to the committee, Ms. Rowley, and at the outset, I wanted to thank you for appearing before the committee. I also commend you for your letter of May 21st to Director Mueller. That letter raises a variety of significant issues that need to be considered during any reorganizing of the FBI. And I can only imagine how difficult it was for you to write the letter and then forward it to Director Mueller and others. So I want to ask you a few questions to clarify some statements in the letter and to seek your views on aspects of the specific reorganization plan. I believe the FBI is the most important law enforcement agency in the world, and I know you do too, and that's why you wrote the letter, and you'd like to have it continue to be a great agency. But in your letter, you detailed the difficulties you and the Minneapolis agents encountered in seeking a search warrant under the Foreign Intelligence Surveillance Act procedures. We've been referring to that as FISA all day. With the FISA and your legal training, what modifications do you believe may be warranted to the FISA statute in order to enable the FBI to obtain such approvals when investigating terrorists?
Well, I heard some of the discussion this morning about the necessity to perhaps take out the working on behalf of a foreign power aspect. In thinking about that, and to be honest, I haven't thought about it a whole lot. And in addition, I have not had that much personal experience in working with the FISA process. Our office is not as involved as other offices would be. However, I think in a way, just knowing what I know about criminal and totality of circumstances, etc., I am not quite sure that it needs to be modified. I think in a way, perhaps what we have is, because probable cause and proving or making these showings that are required are not like a DNA test. They're not a litmus test. You can't put it in and have it come out 100 times the same way. And what can happen is mindsets, and over time, different interpretations, and you can have something becoming unduly difficult when you actually look back maybe 10 years ago. This wasn't the case, and there was basically a lesser standard. I think when you look at totality of the circumstances and probable cause, you are looking at more probable than not. I'm not even quite sure if the FISA, I think FISA statute requires it as well, more probable than not. And I think that if you look at a totality, if someone is working on behalf of a foreign power, these terrorist entities are not like countries. They don't have embassies. They don't send us their membership lists. They don't send us their little organizational charts. I worked mafia cases in the 1980s, and the mafia didn't do that either. They didn't send us their membership. We had to figure it out. And after a few years, we certainly did have hierarchies of each organized crime family. But that was gained from surveillance. It was gained from little snippets of information we would get from wiretaps, that so-and-so is working for so-and-so. And I think that we should be able to use that same type of thing for demonstrating that someone is working on behalf of a foreign power, especially with a terrorist organization. And I'm not sure that the language needs to be modified, but I think we need to realize that it's almost the same type of thing that we're up against. We are not going to get concrete membership lists, organizational charts that we can say, okay, or even the definition of the group sometimes. These groups are very amorphous, and by nature, terrorism groups operate more effectively without having real defined hierarchies and who reports to who, etc. So that's kind of my take on it.
Of course, to a large degree, we're talking about surveillance, and unless you can show that they are operatives for a foreign power, or that you have probable cause to believe that they are part of Al-Qaeda, say in this particular case, you can't get the FISA right to surveil. And see, that's what I think is, and many people are concerned on the other side, that if we grant that broad right, then it'll be misused sooner or later by somebody who would not be as perspicacious as you are, or Director Mueller is. But I see it as a big problem because, as you can see, we basically couldn't get surveillance on, I think, basically all of those 20.
I'm not going to comment on all the facts, but of the case, my analysis of the case is that perhaps that it already exists. You've read my letter, and
right.
I think that it's an obstacle, and I think maybe it's a possibility to consider whether maybe that amount or that threshold should be somewhat eased, especially in cases with terrorists where it's hard to. But I think that things like surveillance and knowing who met who and things like that should figure into it.
All right. Agent Rowley, since your letter of May 21st, the Attorney General has issued a new investigative guidelines that will expand the FBI's investigative tools. Now, given your experience in the field, can you describe in practical terms how will these new guidelines assist the FBI, at least the field agents, in carrying out the FBI mission or missions?
I have not had a chance to really fully read the modifications. I have heard what the three, the main topics that have been brought up about going into public meetings and surfing the net. And there is one additional thing, I think, in those AG guidelines, which delegates down to the SACs the ability and the authority to open up a case, a preliminary inquiry. To the extent that I am definitely, and I think we, the rest of the agents I've heard from, are definitely in favor that when it's possible to delegate down to a lower authority level, we will be more nimble and agile. I am very much in favor of that ability to open up a preliminary inquiry by the SAC. That aspect's good. I do want to maybe at some point get the chance to talk about how, I know people this morning were talking about their fear that some of these new abilities to monitor public meetings. I have a little unique insight because I process Freedom of Information cases, and I read some of our old files from the 1950s, and I will see in there where we got the people back then, for a lot of reasons, got a little carried away. When they went to a meeting, they recorded everyone who came, whether they were important or not, whether the person advocated whatever, you know, a terrorist point of view or whatever. And I see that type of thing that happened in the past. What I think that we need to do is, a lot of it is in the how. And if you go to a public meeting, for instance, maybe we've gotten a little bit of information that someone in that meeting might be discussing a terrorist act. I think it is very good and logical that someone would go and sit in just to make sure that doesn't happen. So if, in fact, a person stands up and says, hey, let's all do this, let's all, you know, undertake this, and gives a speech about undertaking an act of terrorism, we are now going to be in a position that we will know it. Now, if that same agent, even based on a good tip, goes to the meeting and people are merely engaging in their First Amendment rights, here's the thing. Nothing happens from that information. That's the difference in the 50s. We don't come back and record who was there. We do not look into the people